Well, good evening. I'm Professor Michelle Foster, the Dean of the Melbourne Law School, and it's my great pleasure to welcome you to this important event as part of the All Peoples Are Equal National Speaking Tour of the Foundation for Aboriginal and Islander Research Action, working in liaison with the Melbourne Law School's Indigenous Law and Justice Hub. This lecture acknowledges the significance of the International Day for the Elimination of Racial Discrimination. Now, before I continue, I want to acknowledge that today we meet on the unceded lands of the Wurundjeri peoples of the Kulin Nation, a place of their law, a place that has been taken care of by their honoured custodians, past and present, for thousands of years. We pay respect to their leadership in caring for their land through their law. I also acknowledge all the Indigenous nations of this country. In particular, I acknowledge the elders, past and present, and any First Nations people here today. Now, we're honoured tonight to have with us members of Victorian and national Aboriginal organisations, including the First Peoples Assembly of Victoria, the Treaty Authority, Yurok Justice Commission, and the Victorian Aboriginal Legal Service and Aboriginal Community Elders Service. I'm so pleased that many members from the Aboriginal and Torres Strait Islander communities are joining us here this evening. Now, the International Convention on the Elimination of All Forms of Racial Discrimination has been part of the landscape of legal protection for Aboriginal peoples and Torres Strait Islander peoples in Australia, and it continues of significance internationally. Our speakers tonight are 4 distinguished leaders in Indigenous justice. We're honoured to have as our keynote speaker the United Nations Special Rapporteur on the Rights of Indigenous Peoples, Dr. Alfred K. Barume, who has travelled so far to be with us this evening. But setting the scene before the Special Rapporteur delivers his address, we will hear from Mr. Les Malza of the Butchulla, Gubbi and Gamalroy peoples, who, like the Special Rapporteur, was centrally involved in the long process that culminated in the UN Declaration on the Rights of Indigenous Peoples in 2007. We're also proud to welcome Auntie Jill Gallagher, a proud Gunditjmara woman and CEO of the Victorian Aboriginal Community Controlled Health Organisation. And finally, before hearing from our keynote address, we will hear from Associate Professor Hannah McGlade, who is a current member of the UN Permanent Forum on Indigenous Issues. Now, the Indigenous Law and Justice Hub here at Melbourne Law School is a central part of the transformative work on human rights and Indigenous justice being undertaken in the legal profession and the Australian community. And I acknowledge the significant work of former Director of the Indigenous Law and Justice Hub until just a few weeks ago, Professor Eddie Cabillo, who is here with us this evening. I will now introduce our first speaker. Les Malza is from the Butchulla Gubbi peoples in southeast Queensland. Les is recognised in Australia and internationally for his lifetime contribution in promoting and defending the rights of Indigenous peoples. He played a pivotal role with the Indigenous peoples' representatives from around the world in the historic adoption of the UN Declaration on the Rights of Indigenous Peoples. Indeed, he gave the speech on the floor of the UN General Assembly when the Declaration passed. From 2017 to 19, he was an expert member of the UN Permanent Forum on Indigenous Issues. He was the inaugural chairperson of the Foundation for Aboriginal and Islander Research Action, continuing in that role from 1974. Twice he's been co-chair of the National Congress of Australia's First Peoples. And the Indigenous Law and Justice Hub has benefited greatly from working with Mr. Malza, and we hope to continue that relationship to build further support for anti-discrimination measures and human rights. So I welcome you, Les, to the stage. Please join me in welcoming Les.
Thank you for the introduction. Congratulations, everybody, for coming and showing your interest and support for the topics that we're going to discuss. And I particularly appreciate the assistance we've had from the University of Melbourne in getting the Special Rapporteur to the 4 different cities, Brisbane, then Melbourne now, then Canberra, and then Sydney, to maximise the reach that we can do on our messages, in particular from our organisation, which you see up there, the logo, and it's an opportunity for us to advertise our work. We normally don't do it. we normally just go out and do things, and we're all about change. That's why our name finishes with research action, and it goes back to the 70s when we started, that it became an issue in relation to research at the time, that research needed, particularly for Indigenous peoples, to have a purpose, not just for the sake of accrediting more academics and raising tertiary education and so on. So we have, as already shown in the CV, that my life has been actively, from the time I was 20 years old to now, pursuing the rights of, first off, Aboriginal peoples, Torres Strait Islander peoples in Queensland, then nationally with land rights, heritage protection, repatriation of ancestral remains and so on, and then going international to beat racism in the amendments to the Native Title Act in 1998, which is when we fell in with our organisation with the International Movement for Indigenous Peoples. So I need to keep some eye on the slides. What you see there in the picture, I've tried to put some pictures in there because it's going to be boring listening to me, but this is just the way the Indigenous Peoples Caucus would meet before an official UN meeting in Geneva. We would sit down and we wouldn't tell each other what you needed to do or not do. We shared information, and we just helped people to be at their best in terms of responding to the UN during these meetings. So it was coordinated and cooperative, but it was not in any way controlling or limiting in the way that it operated. This just shows you some of the ways in which PERA was operating. We weren't just in the rooms writing on paper. This was the 1982 Commonwealth Games. At that time, Bob Weatherall, who was CEO at PERA at the time, and I went to Africa and visited 8 African countries to talk about racism in Australia, because they knew all about the apartheid system in South Africa, and Australia had done a lot to fight against that apartheid system. By this time, you know, it was still in place when we went over, and we went to the Commonwealth countries throughout Africa to tell them, well, you should be boycotting Australia as well over the Queensland Black Acts, as we called them at the time. So just to give you some idea of what sort of things we were doing at the time. For those who feel that you want to be part of what PERA does, we'd like people to donate. We were well funded by ATSIC when ATSIC existed, because they used us as an agent for some of the policies that they had, particularly on issues like native title, international law, and so on. Government cut all our funding once ATSIC was abolished, so we didn't get any more from government for that period. And we live at the moment, what we're doing at the moment, we're getting from renting out our building, 2 floors of our building, to get enough money to do activities like this. So if you can help, that QR code will work, or there's a URL up the top of that for donation. I will show that at the end of the speak. I have to do this in 15 minutes, so it's going to be a bit of a race. But the point of the message, all people are equals, is meant to get a message across to you, which is nothing new for law students in international law and so on. It's really just to emphasise that the international law has clarity on it, and that the treaty, the United Nations Treaty, the Charter of the United Nations, cannot be any more clear about the rights of peoples. So we're looking here at the introduction. It says, we the peoples of the United Nations determine. So the United Nations is actually made up of the peoples of the world. And it talks about human rights and for justice and respect for obligations that arise from treaties, that particularly those that deal with human rights. And it was the birth, I think, of human rights in international law. This, from 1945 onwards, we've seen a lot happen to it. So in the preamble, it also says our respective governments, so it's really saying the peoples, and we are saying as peoples, our governments, hereby establish an international organisation to be known as United Nations. Thank you. And the purposes in Article 1 are, and I'm just going to the second dot point, to develop friendly relations based upon the principle of equal rights and self-determination of peoples. These are the words we're trying to sell now in the second millennium, that is not understood. And the next one says to promote and encourage respect for human rights and for fundamental freedoms for all without distinction as to race. That is non-discrimination, which is what this week is about, with International Day on the Elimination of Racial Discrimination occurring on Friday. So we're trying to take opportunity for that. Article 2 goes on, and you'll see there one of the criticisms that the Declaration on the Rights of Indigenous Peoples is about the word territorial integrity, but we're trying to get across it doesn't diminish the Declaration at all, because it's already part of the United Nations Treaty to say members shall refrain from using force against territorial integrity or political independence of any state. So even if it wasn't in the Declaration, it was always going to be in law as of that. And that's part of the reason why we finally agreed at the last minute that, okay, put the word in, because to us it doesn't change anything. Thank you. Just a photograph to give you an idea of the times. In the middle there, the woman in the grey is the President of the General Assembly. This is before the General Assembly commenced to consider the declaration, the final vote. We were the Indigenous Peoples delegates who went up to have a meeting. We had already got consent to participate in the meeting by speaking from the floor, and Vicky Towley-Corpus, some of you might recognise, next to the President, spoke on behalf of the Permanent Forum of Indigenous Issues, and if you can pick me out in the spot there, I got the chance to speak on behalf of the Indigenous peoples of the world. Thank you. And we're now also in the UN Treaty. It says in Chapter 11 that there's a declaration, and it's a declaration regarding non-self-governing territories. And in there are important principles, and you can see the word there that, that members of the United Nations accept as a sacred trust the obligation to develop self-government, etc., for those people who did not have self-government. And that's repeated through the declaration there. So member states have an obligation to develop self-government for peoples who don't have self-determination. Again, embedded in the treaty. Thank you. And in Article 3 it says, so we go now to the declaration, and we see the words there that Indigenous peoples have self-determination. By virtue of that right, they freely determine their political status, a real key thing, and I was asking that this afternoon, talking to organisations, particularly with the treaty business here, about, well, what is the political status under these arrangements, or what do they aspire to be in having a treaty in Victoria? Because if you ask anybody on the street or next to you or something like that, what the political status of an Aboriginal or Torres Strait Islander person is, the answer will come back as citizens. But if you ask an Aboriginal or Torres Strait Islander person, you will not hear that they consider themselves to be citizens of the state. You hear words of sovereignty and so on. And by self-determination, freely pursue their economic, social and cultural development. Thank you. I'll quickly go through the first couple of articles in there. So it says, have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means for financing their autonomous functions. And we're pleased to get a response from the treaty organisations this afternoon about having their own source of resources for wanting to do things. So, and they're trying to work a way to perpetuate that fund and sustain that fund without being reliant upon going to a government hat in hand begging for money. Thank you. That's just some of the members supporting the National Congress of Australia's First Peoples, which was the last national representative organisation we've seen in Australia. Thank you. And Article 5 of the Declaration, Indigenous peoples have the right to maintain and strengthen their distinct political, legal, economic, social and cultural institutions. Quite covers the ground. Political, legal, economic, social and cultural institutions, while retaining their right to participate fully, if they so choose, in the life of the state. So this is the sort of thing that Indigenous peoples have aspired to in the Declaration, that they are not forced by the dominant state to a life dictated by the state. It's a right to maintain our distinct institutions. Thank you. And And then in Article 46(1), I put in there the reference we make to nothing in the Declaration would encourage anything to dismember a state in the territorial integrity or political unity of sovereign independent states. But that is still subject to the treaty, the United Nations Treaty, which, if we go to the next slide, there's all, sorry, I'll skip that one, I'll just go on. That's just a shot of the Australian-based Indigenous peoples delegations at the UN in previous years, probably around 2000 and, I've got to think of the time now, probably about 2016, the delegations there. So if we go on again, I wanted to bring up another international declaration which is on principles in international law concerning friendly relations and corporations and states. And you see there that the principle of equal rights and self-determination of peoples constitutes a significant contribution to contemporary international law. We'll go to the next one. And that's me talking at the General Assembly after the vote was taken to remind the member states that this was agreement forged between Indigenous peoples and the states and the UN. It wasn't won by the states alone. It was Indigenous peoples and the UN coming to an agreement about what the rights should be and so on, and that was the significant message of it. If we go to the next slide. Oh yeah, please donate. It's our intention to go to the UN again, this time 3 times, to the Permanent Forum on Indigenous Issues, the Expert Mechanism on the Rights of Indigenous Peoples, and then the Human Rights Council when it considers Indigenous issues towards the end of the year. So we do need to have funds in order to be able to afford to do that. I think I've finished. Might be one more photo. No, I've finished. Thank you very much. I'm sorry to rush through it like that, but please, I hope I've stressed all peoples are equal. And Indigenous peoples in Australia are being discriminated against because they do not have the same rights as the citizens of Australia to self-determination. Thank you very much.
Thank you so much, Les. You've really set us up perfectly for a really fascinating evening. I think that historical and legal framework is a really important starting point. All peoples are equal, words to remember. It's now my great pleasure to introduce our next speaker, Dr. Jill Gallagher, who's the CEO of the Victorian Aboriginal Community Controlled Health Organisation. A proud Gunditjmara woman from Western Victoria, Jill has dedicated over 20 years to advancing Aboriginal health at VACO. Under her leadership, VACO's team and membership has grown to support over 30 Aboriginal community-controlled health organisations across the state. Auntie Jill was also the first Treaty Commissioner in Victoria and has actually, I should say, stepped in at quite the last minute. So thank you very much, Auntie Jill, for being here.
I don't have any slides, sorry, because I was asked about an hour ago to do this, so, but happy to do so. As introduced, my name is Jill Gallagher and I'm a very proud Gunditjmara woman from Western Victoria. My mum comes from a little mission down near Portland, Hayward. Everyone know where that is in Victoria? Western part of Victoria. But she never lived on her mission. It wasn't her mission, it was a government mission. But she lived at Framlingham Mission, which was just outside of Warrnambool. And my mum is one of 18 children, and I'm one of 10. 6 of those 10 children that my mum had were taken away and raised in institutions. But I won't go down that road. So I am the CEO of VACO, and I was the very first Treaty Advancement Commissioner here in Victoria. And my role as the Treaty Commissioner was not to negotiate treaties or a treaty. My role was to set up a mechanism that government could talk to, because we know that colonisation, it was quite brutal. And it had a humongous impact on all our mobs right across this continent. but southeastern Australia copped it first, and before it went into the remote areas of Australia. So it was brutal, it was quick, and it was devastating. And a lot of our communities today still feel the impacts of colonisation, and they manifest in many ways. They manifest when you look at the facts, the data that you see today, that we're overrepresented in the justice system. Here in Victoria, we're overrepresented more than any other state of Aboriginal children in out-of-home care. We're overrepresented in the hospital systems. We have a lot of comorbidities in our communities. We have a lot of comorbidities, our people who go to prison, which aren't being treated. We have a lot of incarceration rates. We have a lot of deaths in custody. And I don't need to stand here and quote figures, because I think you're all uni students, I'm assuming. Yeah, deadly? So you should know. Awesome. But what I wanted to say is that Australia is the only Commonwealth country that does not have treaties with the First Peoples of this country. Victoria potentially could get there, but it's still at risk. Whatever we establish, whatever the First Peoples establishes, and we're in the middle of, not me, First Peoples, are in the middle of negotiations, and so I'm not privy to what's on the table. But I'm hoping it's empowerment. I'm hoping it's recognition. And I'm hoping it's about how do we embed human rights in all that we do. So that's what I'm hoping to get out of if we achieve it in Victoria. Other jurisdictions might come along. Other Australian citizens might think to themselves, well, that didn't hurt us, did it? We didn't lose anything. If anything that comes out of it, all Australian citizens will gain. They will gain from our 65,000+ years of ancient culture and contemporary culture. I don't see white Australians go overseas and brag about their culture here in Australia, the 250 years, but they should be bragging about the 65,000 years plus. Our culture is every Australian citizen's culture, and they should value it and brag about it. Like the Greeks brag about the Greek culture, both ancient and contemporary. The Incas brag about their culture, both ancient and contemporary. All Australian citizens should brag about your culture, both ancient and contemporary. That's what I hope we get out of treaties for our people in this country, for us to take our rightful place as First Peoples of this country. Now, I know it must be hard for you to sit here and really try and imagine what it was like to be a black fella living in the 1800s or the early 1900s or even the mid-1900s or even today. It'd be really hard if you're a non-Aboriginal person. But can I encourage you to Google a publication, and it's called Letters from Victorian Aboriginal Women. And when you read those letters, you will get a glimpse of the horrors of the past. You will hear it and you will feel it. Just recently, we attempted, as Aboriginal people of this country, to get some empowerment, some voice through the 2023 referendum. But we failed. Australia failed to give us that empowerment, that recognition in Australia's constitution. I remember hearing Noel Pearson once say, and I'll quote him, hopefully I do him justice, he said when he was given a talk about how important it is, that empowerment and what it brings with it. It's not about we're getting anything special or anything different from other citizens. It's about that recognition. It's about that we were here, our cultures were here for over 65,000 plus years. I mean, we're older than the Incas, the ancient Incas. We're older than the Egyptians. The oldest mummy is what, 2,500 years old? So it is about Australians recognising your culture. There's a lot of Australian citizens who come from other countries, and I think that makes us even more richer, by the way. But I remember the saying that Noel Pearson said, you other Australians who come from another country, they have two homes. Whether you're Italian, I work with a colleague who's Italian. He was born in Italy, so he goes home to Italy every now and then. But he comes back to this home too. We don't have another home. This is our home. And so when that referendum failed, that was like, apart from 6 million people who voted yes, it was like the rest of Australia slapping us in the face and basically saying, we don't really give a shit. This is our home now. But it wasn't really. I don't believe it was that. I believe it was actually misinformation that was being used throughout the campaign. We saw the opposition play really dirty. They said to Australians, if you don't know, vote no. What a great classic line. Don't know, vote no. What I would have said, if you don't know, find out. Educate yourselves. Because that empowerment also comes along with human rights. Us as an Indigenous community who want to identify us as a peoples, as the first peoples of this country, and we need to be recognised as such. I'm going to finish up. I don't know how long I've got left, but I don't have any. 1 minute. Oh, Lordy. So I am going to finish up, and this is my having a go at the opposition, but don't tell anyone. All right, you got to keep this top secret. But after the failed referendum, we saw a lot of racism that come to the surface. Us as Aboriginal people, some of our people are too scared to wear their T-shirts, especially rural Victoria, especially where there are a lot of no votes. So the racism came to the surface, and our people are still suffering from that. So, and I remember when, what's his name? The opposition leader. I'm being facetious. Mr. Dutton, when he come out and he's most, you know, he potentially could be the next leader of this country. You know, and that's powerful. But he comes out and he says he's not going to stand in front of the Aboriginal flag. That's schoolyard bullying. That's trying to take us back. And so I'm going to leave you with this quote from, what did I say his name was earlier today? Aristotle. Thank you, Mr. Rapporteur. Aristotle. And he said, those who have no vision traffic in division. Thank you.
Thank you so much, Auntie Jill, for sharing your personal insights into the ongoing devastating impacts of colonisation, but also your hope for the future. And I think it's a really timely reminder that we all have so much to gain from treaty. So thank you very much. Now, our final introductory speaker is Associate Professor Hannah McGlade, who's a current member of the Permanent Forum on Indigenous Issues. Associate Professor Hannah McGlade is a Noongar human rights and social justice advocate from Western Australia. She's worked for many Indigenous organisations and has played an instrumental role in establishing services for Indigenous women and children impacted by violence. A former senior Indigenous fellow at the Office for the High Commissioner for Human Rights, Hannah has participated in many United Nations fora to promote Indigenous human rights in Australia, and she's currently an advisor to the Noongar Council for Family Safety and Wellbeing. Welcome, Hannah. Thank you.
Thank you. Thank you to Les and the Indigenous Hub and Eddie Cabillo who've brought me here. It's fantastic. I've had an amazing day hearing from the Koori Assembly, the Victorian Assembly, First Nations, the Yurok and the Treaty Authority, as well as the local ACOs and about the human rights issues. I'm from the Noongar people, the southwest of West Australia. We were the first urban people to establish native title in a capital city in Australia. But, you know, we took note of what the common law was doing around the country, and probably the Yorta Yorta decision might have happened by then, and we thought perhaps we need to go down the Elua settlement stage so as not to risk that kind of you know, ignorance and bias and racism to deprive us of our legal rights. So our Indigenous Land Use Agreement was described as the first treaty in Australia, and by some academics, and I've disagreed with that, because we didn't really obtain self-governance as we're seeing in Victoria, which is really inspirational to us. I think it's really shining a light throughout Australia as to what needs to happen. And without that self-governance, you know, I think our nationhood is really under attack. So it was incredible to hear today the amazing work that the Victorian Koori people are doing, and I really hope this really all happens for you. And this year at the Permanent Forum, our theme is implementing the Declaration rights. So I think this is a really fantastic example of the rights being implemented. I thought I'd just give a few examples of some of the human rights work that I've been doing in the last few years, just to give you an idea of what you can do with your interest in human rights. I'm a really big believer of using the international human rights law system to challenge human rights issues. I grew up in an era where our heritage was never recognised. I also grew up partly in institutions like Sister Kate's. I saw my own brother institutionalised and incarcerated at 15 years of age, along with many other men in my family. I look after children from family today. So one of our big issues is protecting our culture and our heritage, and I think that's true of across Australia, where Aboriginal heritage sites are routinely being destroyed, desecrated, you know, for development and mining, as if our culture didn't matter. We had a heritage law over 20 years which was supposed to protect Aboriginal heritage, but in fact was giving permission every time for mining and development to destroy Aboriginal heritage. There was supposed to be a reform process to improve on the law, but what we found was that the UN Declaration, the language of the Declaration was being used in a way that actually didn't respect our right to say no. And of course you all know about the desecration of Juukan Gorge, which was 46,000-year-old site. Destroyed. So we put up a very strong campaign in West Australia, and I work with Aboriginal cultural leaders from throughout the state to take that matter to the UN Committee on Race Discrimination, and we appealed to them under, I believe, the early warning urgent action procedure, and it took some time, but on Human Rights Day, a year or so after we lodged it, a couple of years ago, they did write to the Australian government and they accepted it under their process, and they talked about Indigenous people's rights to free, prior informed consent. So although that language had been used in the law, really the big problem is at the end of the day, the minister has the right to just say yes and keep doing this. There are also issues about the appeal process through the State Admin Tribunal now, where the minister can just call in an appeal against the minister deciding that. So we've got this live issue now that we actually have got this written advice from the committee that this is a form of race discrimination that breaches the Convention on the Elimination of Race Discrimination. So we're going to keep advocating that. That's one of the issues I've been working on. The review of Australia is now about 3 or 4 or 5 years late. So it's really important that civil society and Aboriginal people go to Geneva when that review of Australia happens, and that we really argue and do our best advocacy there. The other issue that I've been working on most recently concerns what we're seeing around Australia. It's never been a good place for Aboriginal children, right? But it seems to be getting worse in terms of the criminal justice and the youth justice system, and politicians and political parties using tough on crime to pass terrible laws. And we heard what's happening in Victoria yesterday, which is just incredibly obscene and shocking. So in West Australia, we had children put into a maximum security men's prison, a wing. Okay, I mean, this happens where? Maybe in some parts of the southern states or America, but even there, they're actually emptying out prisons. You know, and as a result of this, we've actually had children now dying, 2 children dying. We'll have a coronial inquest being handed down soon into the death of Cleveland Dodd, who experienced this inhumane solitary confinement for, we're just talking weeks, we're talking months, and in some cases nearly years for adults as well. And we know all the risks associated with this. So I've worked with the Human Rights Law Centre since November last year or December, and Professor Megan Davis and others to actually lodge another complaint to the UN Committee on Race Discrimination, that this is a form of systemic race discrimination that's been going on way too long. When I was a young law graduate, 96% of the youth detention centre was Aboriginal kids. You know, all the girls in lockup were mainly Aboriginal. So that's going to go off soon, and we're raising awareness. We're causing Australia, you know, to have accountability, and if we embarrass them in the international arena, all the better. And we had some talk, Caitlin was saying today, about, you know, the pushback on human rights language in Australia. It's certainly very real. The third issue that I'm working on with other academics is the importance of allyship, working on a series of 7 communications to the Committee on the Elimination of Discrimination Against Women, or CEDAW. We've signed what's called the optional protocol to CEDAW, this convention, 10 years ago, but there's never been a communication accepted by the committee from Australia, and there's never been a communication accepted by any Indigenous women in the world, right? So our case is about the heightened risk, the quite serious risk of violence, structural systemic violence that Indigenous women are experiencing, and in relation to what we call Indigenous femicide, the situation of murdered, missing, incarcerated Indigenous women. We've called our communication process 7 Sisters, after a very powerful Dreamtime legend that comes from Central Australia and also goes out around the country. And it's about the women who, sisters who protected themselves. You know, they protected each other and protect themselves in their internal, in the skies and landscapes today. So that's a few of the actions that are underway at the moment. Of course, there's many more issues, and others that I've advocated for in the past are to raise the age, of course, from 10 to the UN was considering 12 when we were advocating in Geneva before the Committee on the Rights of the Children, and we advocated successfully as a delegation to change their view to 14 years. So that is the minimum international human rights law standard for children, but of course it's 10 years across Australia. And although the Northern Territory went up to 12, they went down again to 10. And Victoria has also backtracked, and we in WA can't seem to get any progress on this issue. A couple of other interesting UN interventions. I was just mentioning to the Special Rapporteur on the way here, the Pacific Island students actually convinced Pacific nations to join them in requesting the International Court of Justice to issue an opinion on climate change, which is wreaking havoc in the Pacific Islands. Incredible work by students and their law teachers, you know, because they've got that opinion coming. They've argued the case. Australia has defended its situational position there. All the big states were in there. It's an amazing intervention and development of international human rights law. And I'll also mention the Nyiyaparli people, who are a bit higher up from me in the Yamaji country, and they work with an academic from Queensland to challenge before the Human Rights Committee, which oversees the International Covenant on Civil and Political Rights, the way they were alienated from their native title rights because they didn't have a lawyer and they lost all of their rights without having IT, without having due process. So Human Rights Committee came down in their favour. And we also had the first country visit of the UN expert mechanism on the rights of Indigenous people come to Noongar Budja to look at the issue of contemporary Aboriginal child removals. I mean, half of all the kids in our state who are removed are Aboriginal. Aboriginal kids are 17.5 times more likely to be removed than non-Aboriginal children. We're fighting to have the jurisdiction return like Victoria has achieved. So that was an amazing opportunity to shine a light on that as an international human rights issue. The department were involved in the visit, and they also travelled to Geneva to speak on a panel about it. So this year, as I said, it's actually my last year on the permanent forum. It'll probably go off to New Zealand next to position, and then it might go around the Pacific. It's been an incredible opportunity. And it has been, as Les has pointed out, the history has been really a history that we can be proud of Indigenous people really fighting for the development of the Declaration rights. And it's really a lot up to us too to actually, bring these cases and these issues with our powerful advocacy and, try and bring that change about. Thank you.
Thank you so much, Hannah. You've really inspired us to consider and really to remind us of how the international human rights framework can be deployed in really meaningful ways. And I think you've really resonated with this audience. Speaking for myself as someone who's been teaching human rights law for a long time, I see other colleagues who teach in this building and, of course, many students. So, yeah, I think it's really a timely reminder of the importance of those frameworks. So after these three wonderful introductory talks, I'm now really pleased to introduce our keynote speaker for the evening, Dr. Albert K. Barumi, the Special Rapporteur on the Rights of Indigenous Peoples. Dr. Barumi was appointed a Special Rapporteur in December 2024. He has over 25 years of experience working on Indigenous peoples' rights at national, regional and international levels. As a national of the Democratic Republic of the Congo, Dr. Barumi was among the first lawyers to work on Indigenous peoples' rights in the 1990s in Africa. He was a chairperson and member of the Expert Mechanism on the Rights of Indigenous Peoples, Senior Specialist on the Rights of Indigenous Peoples at the International Labour Organisation, and Independent Expert on the Rights of Indigenous Peoples at the African Commission on Human and Peoples' Rights. Dr. Barumi led a group of African experts who gave support to African diplomats in New York during the adoption of the UN Declaration on the Rights of Indigenous Peoples in 2007. Dr. Barumi holds a PhD in International Human Rights Law with a focus on Indigenous peoples' rights from the University of Essex and a master's degree in Environmental Management from Yale University. He has taught courses on Indigenous peoples' rights in several universities and has published widely on the rights of Indigenous peoples. Thank you so much for being here, Special Rapporteur. We're very much looking forward to your presentation. Thank you. I should just mention there will be some time for Q&A at the end, so please hold your questions until the end. Oh, you're all organised there.
If I can remember. Does it work? Oh, yeah, works. Good afternoon. What time is it? So I have less sense of time, so I suppose it's late afternoon. So good afternoon, everybody. It's really a pleasure to be here. I'd like to thank Les for inviting me here to come. I've known Les for more than 30 years. I said this when we were at these meetings. Yeah. Les called me a couple of days ago. I was in Thailand, and he said to me, "Albert, you need to come to Australia." And I said, "No, Les, you must be kidding me, please. I cannot come to Thailand." I said to Les, I was in Thailand, but I was heading straight to Nairobi. And I can't imagine myself doing Thailand, Nairobi, and coming to Australia. Anyway, here am I. It's really a pleasure. It's so if I'm seriously jet lagged, so if I fall off, I hope somebody will sort of pick me up. It's a pleasure to see some people I've known, I've worked with in this room, including in Geneva, former Australian diplomats, and they did good work for for us. So I asked Les what he wanted, what was all about the meeting in Australia. And they said, well, it's a harmony week, and we're talking about everybody, all the people were equal. And I asked him for more information, and he sent me a short concept note. He did. But I really had difficulty in sort of squaring down what I could talk about. We did have a conversation on the phone and tried to understand what I could possibly share. And it wasn't very successful. So I decided, I knew because of constraints, I've just been appointed in January for a special rapporteur to go on a country. You need to write to that country, and you need to wait for a response so that you can go. And when you go, then you can talk to everybody, and then you can say whatever you want. If that doesn't happen, and you happen to go, you can't just say anything you want. So you understand my difficulties. You can't talk about the country. If you talk to press, you really have to be careful, and so on and so forth. So I decided I'm going to do some theory, read some basic things, because I think, in my view, I think humanity, and this is my pitch, I think humanity is entering a new phase, new global order. And it has, in my view, never become so important, maybe to remind people of their basics. So I decided maybe I remind you of the basics about 4 concepts, which in my view makes the foundation of the peaceful world a little bit stable that we have known. And one of those principles is, one is equality, in my humble view. The second is the norm of non-discrimination. The third is right to self-determination or self-determination. And the fourth is friendly international relations. Those, in my view, are the pillar of the international order that we have enjoyed for years, and which maybe, if we're not so careful, we might not be seeing for long. So really, ladies and gentlemen, I'm going to read something. It's the human rights principles of equality and non-discrimination are part of the foundation of our modern world that we know following the 2 world wars, which unfortunately revealed to us what prejudiced view, discrimination could do. These 2 principles, which are equality and non-discrimination, in theory were described at a certain point as 2 faces of the same coin. The norm or the principle of non-discrimination, as it's asserted in the UN Declaration on Human Rights, states, and let me quote, that everyone is entitled to all the rights and freedom without discrimination of any kind, sex, color, language, religion, and so on. It served the norm or the principle of non-discrimination as a foundation principle of the United Nations. it also guided the Universal Declaration on Human Rights, and it still is the central pillar of any democratic state. The principle of equality, on the other hand, is equally a strong principle enshrined by the Declaration, and which stated, let me quote, "All human beings are born free and equal in dignity and in rights," end of quote. But it's rather Article 7 of the Declaration on Human Rights which came to indicate what equality actually meant. And that article specifically indicated that it meant equality before the law. And it stipulates, and let me quote, "All are equal before the law and are entitled without discrimination to equal protection of the law." This is to say that equality does not mean to be the same. People will always be different in culture, in weight, in height, in origin, in race, and way of life. The goal of equality is not to make everyone identical, absolutely no, but to ensure respect and fair treatment by the law. Indigenous people, for instance, will always be indigenous people and will continue to be indigenous people with their own unique way of life, traditions, and culture, which are distinct from other members of society. An Oxford professor says, and let me quote, "Equality does not mean all people doing the very same work or living in very similar type of home. It does not mean people being exactly the same. It means moving toward all the people a principle of being respected and fairly treated." End of quote. Equality is about ensuring that we all enjoy the same right regardless of what we are by nature. In other words, what we are by nature, and which is skin color, sex, cultural identity, origin, etc., should not make one become burdened or disadvantaged. Nor should someone be entitled to privileges or advantages because of what they are by nature, which can be color, sex, or cultural identity. A professor at the University of Singapore says, and let me quote, "Equality focuses on treating the like alike in terms of burden and privilege." End of quote. This is to say, as a word, that we human beings, considering as the Declaration says, and I quote, that we are born free and equal in dignity and rights, we should therefore be treated alike. But equality includes also special measures, which aims at uplifting those in disadvantaged condition to ensure they can enjoy rights equally. The Committee on Elimination of Racial Discrimination said in its General Comment 22 recommendation states, let me rapidly quote, "Special measures should be appropriate to the situation to be remedied, be legitimate, necessary in a democratic society, respect the principle of fairness and proportionality, and they should be temporary. The measures should be designed and implemented on the basis of needs, grounded in a realistic appraisal of the current situation of the individual or the communities. This is said as it was by one scholar who, I quote, "Equality can lead to dissimilar treatment through positive action or method, and remove systematic barriers or stereotype that disadvantages particular groups in terms of their participation in public life." Equality is not just what we just said. It is also a foundation of friendly international relations and the ground for self-determination. Because the Charter, the United Nations Charter, says that it aims at developing friendly relations among nations based on the principle of equal rights and self-determination. End of quote. This is the reason the United Nations declarations reaffirm the same principle of indigenous people being entitled to equal rights and the right to self-determination. Let me a little bit zoom on to the right to self-determination. The right to self-determination was conceptualized in the 60s and devised so that marginalized peoples and nations would regain their dignity and control over their destiny and well-being. It was construed as a collective rights meant to trigger a paradigm shift in decision-making so that nations or peoples could make tangible change to their living condition. The right to self-determination has evolved since then to include both external and internal aspects. The right to self-determination is considered by some as a fountain right, from which many other rights flows, such as cultural rights, language rights, right to autonomy, self-governance, right to living in dignity, and many other rights. Without the right to self-determination, indigenous people will not enjoy so many other rights. Likewise, if a state does not guarantee the right to self-determination for indigenous people on its territory, such a state wouldn't be able to provide or to deliver on so many other rights for those indigenous peoples. The right to self-determination is for nations and people what the right to life is for individuals. Without the right to self-determination, nations or peoples can cease to exist as such, just like a human being ceases to exist without enjoying fully the right to life. The existence of a nation or a people is severely impaired when it no longer enjoys fully self-determination. Just like a human being survives in miserable conditions when his or her life is seriously threatened. Equality and non-discrimination do not bring chaos, division, or disharmony in society. They do not threaten national unity, as some have argued. On the contrary, equality and non-discrimination are essential for internal stability, prevention of social unrest, because inequality and discrimination in contrast foster resentment, disrupt harmony, make a country vulnerable. The United Nations Declaration on the Rights of Indigenous Peoples is a unique international instrument devised to enable countries reconcile with their history of indigenous people marginalization and discrimination. It is a restorative instrument which does not seek to make indigenous people enjoy special rights or enjoy more rights than others or be in a privileged position. The declaration simply reformulates the very same pre-existing human rights guaranteed under international law with a view to addressing the uniqueness of injustices and historical wrong that indigenous people suffered and continue to suffer from. Experiences have shown that protection of indigenous people's rights reinforces national cohesion, enhances stability, and improves a country's international image. States have interest in promoting equality and non-discrimination. One scholar argued, and I quote, "In more equal countries, human beings are generally happier and healthier. There is less crime, more creativity, and more productivity." Ladies and gentlemen, I would not like to conclude my statement without underlining the fact that over the last 7 decades, the world has enjoyed a relative peace and stability, grounded in the norms of equality, non-discrimination, self-determination, and friendly international relations that the founding father of the United Nations Declaration on Human Rights established. An international law-guided world order has prevailed just up to today because of those principles. Over the last years, however, some have started to take the current peace, stability, and international security as granted. The world is somehow becoming complacent with international law principles of equality, non-discrimination, international friendly relation, and self-determination. Growing populist rhetoric, unilateralism, questioning of fundamental human rights principles, and resource-driven state interests undermine multilateralism system and prioritize economic interests over basic human rights principles. Others have gone as far as arguing that equality and non-discrimination are counterproductive and dangerous for national cohesion. The current global context gives us a glimpse of what the world could become or look like if we were to be solely guided by personal interest of those in powerful positions. We are witnessing early signs of a world in which the vulnerable, the weak, the poor could be further marginalized and live on margin of society. This is, in my view, a wake-up call. Humanity needs to come back to its sense. And the youth particularly must decide which kind of world it wants to live into tomorrow. No one state or individual, would be safe if the principle of equality, non-discrimination, self-determination, and friendly international relations were to be abandoned as normative framework for the world order. More than ever, I do think these principles should be reaffirmed, and their grounding of human relations, of humanity, become a central preoccupation for inclusive, unified, and tolerant states that we all seek to live in. I thank you.